Welcome and hello and good evening, and thanks for joining us today for Finding Justice, Challenges and Opportunities in BC's Legal Aid Landscape. I'm Lean Evans. I go by they, them pronouns, and I'm the first Vice President of the Canadian Bar Association BC branch. And for the next hour and a half, I'm the moderator of this panel. This webinar is hosted by the Continuing Legal Education Society of BC in partnership with the CBA BC. And it's being hosted from the traditional and unceded territory of the Coast Salish peoples, including the Squamish, Tsleil-Waututh, and Musqueam nations. In addition to acknowledging the land from which this session is hosted, I also take this moment as an opportunity and a personal reminder to be conscious of the unique and often increased barriers to access to justice faced by Indigenous people and the need to center Indigenous perspectives and empower Indigenous people in the work that we do. We have four very informed leaders of legal aid in our province here with us today. And it's from them that we're going to be learning and not from me. I'm here to learn from them as well, I hope. First, we have Aleem Bharmal, KC, from the Community Legal Assistance Society and Bench Chair of the Law Society of BC. And I have to shout it out, former president, last year's president of the Canadian Bar Association BC. Thanks for joining us, Aleem. We also have Michael Bryant, the CEO of Legal Aid BC. Thanks for joining us, Michael. And Wendy Jackson, the Executive Director of the Legal Access Policy Division at the Ministry of the Attorney General. Thanks for joining us, Wendy. And finally, we have Amanda Carling, the CEO of the BC First Nations Justice Council. Thank you for joining us, Amanda. During the session, we'll learn from and apply the collective knowledge of these wonderful folks who've joined us on three main legal aid topics. First, what's the current state of legal aid in BC? Second, what are the most pressing policy issues related to legal aid in BC? And third, what are some of the possible innovative approaches to legal aid service delivery? And with that, I'm going to launch in to our first topic, which is the current state of legal aid in BC. Legal aid, as everyone who's joined us surely knows, is an essential service, public service in BC. It's meant to protect our most vulnerable and marginalized citizens' ability to access justice. So we're going to talk about the perception of the current legal aid system in BC and how it serves communities and what impacts we're seeing on the ground. I'm going to start off the discussion with a question for Michael. Legal Aid BC is the primary legal aid service provider in the province. Can you tell us about the services your organization provides, and in particular, what, if any, changes have been made in recent years?
Hi, everybody. Legal Aid BC is got a budget of $100 million. It is has 200 staff members. We work with about 800 lawyers, private tariff lawyers. We only do criminal, family, a little bit of family, child and family services, so child welfare, and immigration law. Over half of what we do is criminal. Before 2003, Legal Aid BC did a whole bunch of other things, but we don't do any of those anymore, and other service providers do, and you'll hear about that. Legal Aid BC, criminal work makes up about half to a third of our work. We receive around 1,500 applications a month from people looking for a lawyer, and just over 80% are approved for criminal. For family, it's around 600 to 900 people trying to get legal aid per month, and only about half of them get approved. Immigration, it's up considerably over the last few years, and it can get up to 600 people per month seeking our refugee services, and about 85% of them get legal aid. And lastly, child welfare, around 200 people per month apply for legal aid, and about 70% get it. So that's the facts of legal aid and the service that we're providing and the work that we're doing. And I think I'll answer what changes have been made in recent years in a future question, other than to say this. I think for a long time, Legal Aid BC was primarily transactional. We just found a lawyer for the client. And what we've been trying to do over the last couple of years is to be strategic so that we can win more for our clients. and not just get them a lawyer and then pay the lawyer. So the strategy has moved away from cost containment to cost containment plus getting better outcomes for our clients. More on that later. Thanks for having me.
Thanks, Michael. And next, we're going to move over to Wendy. In addition to the services provided by Legal Aid BC, there are other free services provided to British Columbians to address their legal matters. Can you tell us about these other services that the government funds, and in particular, again, what, if any, changes that have been made in the past few years and the impacts of those changes?
Yeah, thanks so much for the invitation to participate. Obviously, there's an entire continuum of services, legal and non-legal services, in the sector. Legal Aid BC, obviously being the one I think that's most well known. The budget that they had in this most recent year is about $128 million, which is, I think, maybe surprising to some people. It's about $53 million more than government spent in like 16-17. So obviously, not able to provide counsel to everybody in all situations, but it's a significant investment. And there are other services that we provide to help people in the sector. As far as changes, that have been made, the impacts that have been made. Sorry about that. So, there was some significant financial eligibility increases made recently. And so from about December 2022 to December 2023, about 3,000 additional contracts were issued from Legal Aid BC. So that's 3,000 people who weren't receiving services prior to that. And additionally, there are a number of unbundled services as well. I think people often talk about full representation services, but there are a lot of unbundled services, both in the criminal and family areas, that allow for people to receive assistance with other matters than perhaps just the entire continuum of their legal matter. But in talking about the continuum of services, government also provides services directly, so it doesn't just fund Legal Aid BC. We've got an entire division of services called Family Justice Services Division. These employees, we've got 19 family justice service centers across the province and 5 justice access centers across the province. They provide legal information, needs assessment, referrals, and dispute resolution services to people throughout the province. There's also a child support recalculation service that's available. It was initially a pilot, but it's now available in all court registries across the province. And Amanda will speak, I'm sure, about the Indigenous Justice Centers, so I won't get into that. And then in addition to that, there is a network of legal clinics that we fund through the Law Foundation, both community, like what have been traditionally kind of known as poverty law services, but also specialty clinics such as housing, disability, and the Society for Children and Youth now provides representation for children and youth across the province. Yeah, I think that's pretty much what I'll say about that for now. But again, as Michael alluded to, there's another question coming up to talk about successes, and I'm happy to chat more about that then.
Thank you, Wendy. And Amanda, we understand BC FNJC recently announced the opening of 5 new Indigenous Justice Centres in BC. The organization has stated that the current legal aid regime in BC is not adequately serving Indigenous people. Can you tell us a little bit more about that and how Indigenous people are affected by the system as it is?
Yeah, thanks for the opportunity. I want to start by acknowledging that I'm on unceded Syilx territory, and I'm really grateful to be here. I'm a Métis woman from Treaty 1, so I'm really honored to serve the BC First Nations Justice Council, a group of 6 BC First Nations leaders, and just really happy to be here. BC First Nations have been advocating for transformation of the legal aid regime since much longer than I've been here in this province. And our legal aid transition team, led by Director Courtney Dawes, who I'm here on behalf of today as she's away, and supported by members of the Indigenous Justice Secretariat at the Ministry of the Attorney General, recently conducted 34 in-person engagements in 18 communities across the province, along with 4 virtual engagements. In these sessions, we asked First Nations community justice workers, community legal service providers, partner organizations, and legal professionals about the effectiveness of current legal aid services for Indigenous people in British Columbia. Our research and the feedback from this engagement supports what First Nations have been saying for decades, and that is that the current legal aid regime is not working. The status quo of current legal aid services contributes to the over-incarceration of Indigenous accused and the increased apprehension of Indigenous children. Some of the specifics, we won't get into all of the specifics because, of course, with that much engagement, we've got a lot of feedback and we're putting it into a What We Heard report that's going to be made available to our partners in this work and the public as well. But big headlines include restrictive eligibility criteria. Criminal representation is limited to charges where a person could face jail time. Financial eligibility restrictions. Verification process can also be a barrier for individuals. Community and legal professionals, and I'm sure if there are legal aid lawyers on this call, this will be familiar, but often we have to manipulate legal aid applications in order for clients to be eligible for legal aid. Legal aid services only become available too late in the process, and I think, these are not new things to hear, but it's really important to hear them from the folks out in the communities. Legal aid lawyers under the current system have an insufficient amount of time to spend with their clients, and this is a huge issue for Indigenous people. One of the other findings that I'll talk about briefly is lack of cultural competency, and that is true in some cases, but often it's just a lack of time to spend getting to know clients and understand their world, their worldview, where they're coming from, their life experiences in order to represent them properly. There's a lack of accessibility. Lack of resources required for legal aid applications and to take part in the justice system. And that's, things that we take for granted, internet, phone, computers, printers, all of those things. And participants notice that legal services are often not available and response times are slow due to a lack of in-person services. I mentioned already cultural competency of legal counsel. We know systemic racism within colonial institutions is a reality for many Indigenous people. It was raised repeatedly throughout our engagement sessions. We heard that Indigenous people experience unjust treatment from state-imposed legal systems at the hands of largely non-Indigenous legal professionals who lack crucial awareness of history. The fact that the colonialism is ongoing and continues to play a role in Indigenous people's lives. There are many experiences of people where they've been treated in rude and derogatory ways by all kinds of practitioners in the system. Just to offer a personal anecdote, before I worked for the Justice Council, I worked for an organization called Innocence Canada, and I also taught a course on wrongful convictions with my friend Kent Roach. When I was teaching with Kent, we heard about the case of Richard Catchaway, and it didn't get a ton of media attention. But I think it's important for people to understand what happened to Richard. In 2017, he pleaded guilty to a break and enter. It had happened in Winnipeg. He told his lawyer that he didn't remember doing the break and enter, and he didn't think he was there. His lawyer knew he was one of the few people who had received a diagnosis of fetal alcohol spectrum disorder. And nevertheless, his lawyer helped him plead guilty. He received a sentence of time served, because of course he didn't get bail. But he also told the PO who wrote the PSR in Manitoba, there was no Gladue report, that he didn't remember the crime. Subsequently, a prison administrator sent Catchaway's lawyer documents establishing that at the time the B&E occurred in Winnipeg, he was incarcerated in Brandon, Manitoba, a full 200 kilometers away from where the crime occurred. So the question is this unique? Is this a unique case? And I think that it is. Only in that we found out about it. The fact that Mr. Catchaway received a remedy for his miscarriage of justice is, required a series of miracles, truly. And, in addition to teaching with Kent, recently we launched the first Canadian Registry of Wrongful Convictions, and we have 89 cases in that database. And of those 89, 16 of the people who's received remedies for wrongful convictions were false guilty plea wrongful convictions, and half of those were taken from racialized people, including 4 Indigenous men. So, the question is, did the failures of legal aid contribute to these miscarriages of justice? And the answer, I would say, is almost certainly. But the reality is we have a justice system that makes pleading guilty when you're innocent rational. Most of the wrongly convicted people that I've met have said that they would do it again. It was the right decision for them. It was the right decision for their family. And that's why, and I'll put a pin in it soon, I promise, but that's why BC's First Nations Justice Strategy looks at reform of the whole system. Legal service provision through our Indigenous Justice Centers and Legal Aid Transition is a part of that, but it's only part. So I look forward to telling you a bit more about our justice strategy. Miigwech.
Thank you so much, Amanda, and I look forward to hearing more of what you share in the next questions. Aleem, turning over to the services that CLASP provides, can you tell us a little bit more about what those are and the impact that has on British Columbians?
Thank you, Lee. Thank you for having me. And like you, I'm coming from Coast Salish territory, nations of the Musqueam, Squamish, and Tsleil-Waututh. So the Community Legal Assistance Society is part of a larger public interest law sector. We've been around, we're one of the most longstanding and largest legal organizations of our type. We've been around for 50 years, and we provide free legal assistance to people who are facing issues with housing, income security rights, workers' rights, mental health rights, and human rights. Every year, we assist thousands of people in BC in need of legal services, with legal information, summary advice, representation before tribunals and courts, and publication of self-help guides and resources. When we started in 71, we were basically 2 lawyers, and today we are over 20 lawyers, 50 staff, including quite a number of legal advocates. And so we've expanded over time. We basically do a high volume of frontline legal work in the areas mentioned, and also some ongoing systemic test case trial and appeal work. We've represented clients and appeared on our own behalf, representing the main parties or interveners at all levels of court, including the Supreme Court of Canada multiple times in that systemic test case work. We consider ourselves an umbrella organization that provides these wide-ranging critical legal services through different programs with different funders, including primarily the Law Foundation of BC, who funded us from the outset. Legal Aid BC is a major funder for our mental health law program in particular, the BC Attorney General that funds our human rights, and most recently, over the past few years, the Federal Department of Justice. So specific examples, those members of society who are disadvantaged or face discrimination and come to our organization, for example, to get legal assistance with their representation before the Mental Health Review Board, when challenging their institutional detention for secure treatment under the Mental Health Act or under the mental disorder provisions of the Criminal Code. So that work engages clients' fundamental rights of liberty and security of the person. They can come to us if they have a case before the BC Human Rights Tribunal and they're alleging their human rights have been breached or violated in the area of employment, tenancy, public or private services, and all the other areas covered by the BC Human Rights Code. They can also come with us for judicial review or appeal issues in all those areas we covered. Again, that includes housing, income security, workers' rights, mental health rights, and human rights. So I think that's a good general overview for the first question of what we do and the services we provide in the province.
Thanks very much, Aleem. And before we go into the next section, we have one question that's come forward, and I remind everyone again that you're free to put questions in the Q&A as we go along, and we'll answer them in between sections or at the end. But we do have one question at this juncture for Michael, and the question is, family violence is a leading cause of homelessness and poverty for women. One way to prevent homelessness and poverty is fair property division for women leaving violence. Lack of assistance with fair property division is a serious access to justice issue for women and marginalized genders experiencing and leaving family violence and their children. Michael, can you please speak to legal aid's policy where covering property division is incredibly limited in almost all contracts and the changes that are being made to address this serious issue?
Agree with every word of that. And the status quo at present is, unsatisfactory to everybody involved. The coverage, the eligibility for folks to get legal aid, as I mentioned, is very low. You have to be, in many cases, at or near the poverty line. When this involves violence against women, when it involves intimate partner violence, which more often than not is against women, then there are some things that we try to do and offer some advice, but our ability to do much is sufficiently unsatisfactory that we're being sued. And so we're in the middle of litigation right now, the Legal Aid BC and the province. And it's about that very issue exactly. And so the status quo, I used to be a politician. I used to be an attorney general. I used to be accountable for these things. But I'm not that anymore. I do the best. We all do our best with the budget that we're given, and that's where we're at right now at Legal Aid BC. But I'm optimistic that this will change in the future. I don't know when exactly, but we have an election coming up, so that is an option for folks, and that also creates maybe an opportunity for us. I think that's the best way I can answer that question.
Thanks, Michael. And Wendy, do you have any comment from the government perspective on that?
Sorry, it took me a minute to find the mute button there. I don't think I want to address the litigation. Yeah, I mean, I guess obviously it's very important for us to collectively to be listening and working together to try and make improvements in the system. Always wanting to hear directly from service providers and advocacy organizations as to what we can be doing better to make improvements to services. And so obviously the questioner did appreciate that there is some assistance, whether whether we could do more and be better. Again, very happy to engage in that conversation on an ongoing basis.
Thank you. And I'm going to stick with Michael and then Wendy just a little longer into the next section, moving into more of a policy discussion. And if you have any additional recent successes or current challenges that you're grappling with in the system and in the work that you're doing. We'll start with Michael on that. Michael, you're muted. You're still muted. Unmuted for a second and then.
Okay. I think I was trying to unmute at the same time as central control was unmuting me, and we were crossing. Anyways, I apologize for that. So let me do the successes first. So I talked about how we're trying to do things differently and more strategically, and what that involves is sharing more information, knowledge management between council, and also trying to coordinate multiple matters in a way that we work with the lawyers and try to coordinate them and do this in a way that has a positive impact on the client. Where this is coming from is that's what the Crown attorneys are doing. They do that. They do have strategies, jurisprudential strategies, and they have policies which try and get the outcomes that the attorney in their quasi-judicial capacity would seek. Prosecutors don't say we do this to win, but on the defense side, we can say this. We're doing anti-racism work. We're doing reconciliation work in that obviously our population is disproportionately being investigated, charged, and incarcerated, the racialized and Indigenous populations. So we can make it our strategy to win. An example of this is what happened in Fairy Creek. In Fairy Creek, as you know, there was 1,000 protesters, hundreds and hundreds, maybe 1,000 folks were arrested. And at a certain point, there were 150 facing criminal charges. Of those 150, we got the 15 lawyers together. We used a triage system to get the defendants connected to one of the lawyers who was working on those files. We found the best fact situation that we could, and we took issue with the way in which the injunction was. There was a short form injunction done by the RCMP. We challenged it. We succeeded. It was appealed to the Supreme Court of Canada. By we, I mean defendants. As a result of this, almost 150 charges had to be dropped by the Crown because of a strategy that tried to work with the scale that we've got at Legal ABC and connect lawyers together, and in essence connect the client's lawyers together, and do our best to try and prioritize as much as we can the better outcomes for clients. So that's an example of recent success. I'd say the most recent challenge that we're facing right now, it's actually not a provincial matter. It is the explosion of refugee applications that we're getting. And the Department of Justice is supposed to be funding the work that we do in defending refugees in their applications. And it's entirely chaotic. And so we'll get a ridiculous budget at the beginning of the year, and we'll have to go back and ask for more money. We have to tell immigration lawyers, well, we might run out of money, so we won't be able to pay any of your contracts at the last minute. We get some money. Anyways, it makes the provincial attorney general look like the Four Seasons. It's chaos. So it's a big challenge, and it's also flooding our Legal ABC system. In that we've got triple the number of refugee applicants who are coming into our system. Last thing I'll say is we have 10 new navigators. They are non-legal folks who assist clients, particularly clients facing complex challenges, and we basically help them navigate the system, our system and the criminal legal system, and we work with lawyers to try and get better results. We're doing that a lot with the navigators. There we go. That's my answer.
Thank you, Michael. And Wendy, same question to you. What are some successes and challenges that you're currently seeing in the system?
Yeah, I mean, I think I would note a number of successes as well as some challenges. So yeah, I spoke earlier about the changing eligibility thresholds in December of 2022. There were significant changes made to financial eligibility to allow significantly more people qualify for service. And so we aligned the eligibility criteria with the market basket measure, which is a poverty measure, standard measure. But what that actually did was, for a family of 2, increased eligibility by 40%, and for a family of 4, increased eligibility by 25%. And so while I know that there's still a gap between services that everybody can afford and what who can qualify for legal aid services, it's still a significant investment, and I think has allowed, as I said earlier, like 3,000 more people to get service in the last 12 months, which we see as a success. In addition to the family legal or limited representation contracts, which is a large expansion of coverage, 14 hours of general prep and then up to 3 hours of court to help people with family law matters that don't require there to be a serious risk of harm to the client or their children, is providing significant benefits to people. And then another success that, I mean, it's starting to get a little bit dated now, but it's quite close to my heart, is the agreement that we reached with the Association of Legal Aid Lawyers to allow us to increase the tariff rates that we pay to counsel. The initial agreement was reached in 2019, and we continue to sit down and negotiate on a 3-year basis to ensure that service providers are being paid fairly and appropriately. From a what people think classically again as of Legal Aid BC as the legal aid continuum, but the province is piloting in two registries, although I think they're permanently a family model called the early resolution model, right, which is providing multiple services upfront to people before they go to court. So it's an interview, it's a needs assessment, it's filling out forms, it's getting together with the other party and seeing whether or not matters can be resolved before having to go to court, or at least narrowed, issues can be narrowed before people have to go to court. And so both the Victoria Registry and the Surrey Registry have undergone evaluations. There have been significant successes in narrowing those issues and keeping people out of court when they don't need to be there. One of the referrals, obviously, that you get from that model is for legal advice. And so, Legal Aid BC is government's partner in a number of areas, this one as well. And people can go and do some consensual dispute resolution and then get referred to Legal Aid BC to get some advice on their agreement before they enter into it, which is, again, providing significant benefit to lots of different people. From a challenges perspective, I think we are continuing to monitor demand for service. Demand continues to rise post-pandemic. And Michael spoke to the immigration pressure on Legal Aid BC. It's on all public services. The number of, there's an increasing number of people coming to British Columbia. They all need healthcare, they all need education, they all need housing, and a good number of them also need legal aid services. And so monitoring what that looks like and how we can be in the path of the client to assist them better. Also experiencing labor market challenges, right? People talk about the graying of the bar and the number of people who continue to take legal aid cases. So, trying to do our best to respond to that, support Legal Aid BC in their recruitment and retention efforts, and trying to train new lawyers to get those opportunities to do legal aid work. Those are the challenges that I would identify.
Thanks, Wendy. And we know as well that in addition to facing significant financial circumstances and barriers, they're also and complicating further legal issues are interrelated social issues such as housing issues, concerns related to addiction, family violence, mental health, and the legal system and the process can be even more burdensome and complicated when people are dealing with those interrelated issues. And I'm going to turn to Aleem to see what his comments are in terms of how class can help address gaps in legal services as they relate to mental health, housing, human rights, and other issues.
Thank you, Lee. Well, I discussed in my earlier answer a basic overview of the services we provide in all these critical areas. In terms of expanding the scope of what is covered and what can be addressed, I'll give you a few examples and then I'll talk a bit about the gaps that still exist. So one issue, for example, is in our view, we have a regressive Mental Health Act in this province compared to other provinces, and we've challenged it constitutionally, specifically on the basis that if you are in secure treatment, you deemed to consent to whatever treatment is thought should be applicable to you, even and there's no capacity assessment, or as there are in other provinces. So we've challenged that constitutionally. I see Connor's here with the great assistance of McCarthy Tetro on a pro bono basis. And we went up to the Supreme Court of Canada on a side issue, it was on standing. And so now we're back fighting the merits of that. Another example would be we also did a very landmark report on some of the gaps in the mental health law system, including that when you are first certified for secure treatment, you're not given the information you need from an independent legal provider about your rights. And so the government is now addressing that. We weren't the only ones who raised this issue. The ombudsperson also raised it. So another example is more recently, we represented a mother, an Indigenous mother, who on the facts that were accepted was treated very prejudicially by the child welfare system. And we looked at the whole context and history of the system, but it was found that she was treated in a systemic, stereotypical and biased manner. Unfortunately, that decision was recently overturned by the BC Supreme Court. It had been a landmark, unprecedented decision. And we do have issues with the interpretation of human rights law that was applied. And that is a case that is likely to be appealed. I want to thank my co-counsel, Francis Rosner, who was on that case with me at the trial level or the hearing level, and my colleagues who took on the judicial review. So those are some of the ongoing battles we take on to improve the justice system. And in terms of our wide-ranging services we provide, gaps, there's no question gaps still exist in the areas that we cover. In mental health, for example, there's no clearly defined resource for people wishing to challenge secure treatment admissions against their will and consent under statutes beyond the Mental Health Act or Criminal Code, such as the Adult Guardianship Act or the Health Care Consent and Care Facility Admission Act. Also, there does not always exist sufficient funding to provide full representation and assistance through the various legal systems in many of the areas we cover, as opposed to often self-help, limited summary advice, and what we often refer to as unbundled legal services that only provides assistance with a particular issue or step in the legal process. And now some of the services that we provide, albeit limited, specifically with respect to sexual harassment in the workplace, which engages not just human rights, but civil, employment, criminal, work-safe legal issues, as well as our newest program dealing with supports for those who have suffered sexual assault, be it in the workplace or not. These appear they might not be continued to be funded by the federal government as they have been over the past few years. That was our most recent funder for some of the services we provide. So critical gaps remain that require more funding for traditional personal legal assistance that can't simply be solved through technical or procedural innovation alone, although I'm happy to talk about some innovative ideas when we get to that section of the panel. Thank you.
Thanks, Aleem, and thanks for all your hard work at class. Amanda, back over to you. There are many visible and invisible barriers that exist for Indigenous people seeking to access justice, which I'm sure you're more aware than most of us here. And this is particularly important, not only in the context of Child, Family, and Community Service Act proceedings, but also in the context of Family Law Act matters. Things like we've spoken a little bit about already, a division of family property, debt, child and spousal support, parenting arrangements, and protection from family violence. Do you see a need for legal aid family law services that are specific for Indigenous people? And what kind of impact do you think would result from increasing that scope of legal aid services for Indigenous people to include family law?
Thanks for the question, Lee. So yes, I could end there. Yes, absolutely. To Michael's point, it's about resources right now. So for folks who don't know, in our Indigenous Justice Centers, which I'll talk a little bit more about, We're providing criminal defense and child protection legal services, as well as wraparound services. And occasionally a person's child protection matter will be so intertwined with their family law matter that the lawyer is able to work on that as well. But right now, for the most part, we don't have capacity and funding to do it. One of the key recommendations from our fall 2023 engagements was to ensure that legal services included a broader scope of family law services than what is offered in the current legal aid system. That includes, separation and divorce, customary adoptions, child support, including challenging inaccurate or outdated child support orders, as well as spousal support. Families, as Samantha said in the question earlier, families that are affected by domestic violence and intimate partner violence need additional supports and services in this area. And I think in a lot of cases, one of the results could be prevention of involvement with the criminal justice system if there was more support in the in the family law area. One of the wonderful things about the colonial law is that often we wait until a problem is so bad to try to solve it, that we don't really get great outcomes. Family law, child protection, criminal law are all interconnected, and providing supports will contribute to overall family health and healing. One of the questions, and I don't know, Lee, if I'm getting ahead of us by speaking to Anne's question, and I think Michael might be able to speak to the current state in terms of legal aid coverage for harvesting. But what we've heard time and again, and not just on legal aid engagements, but when we're attending at PTO meetings, when we are visiting with community for other purposes, harvesting charges are having huge impacts on individuals, and harvesting traditional foods isn't just about feeding your family, it's about feeding your soul, it's about practicing your culture. And the way that the DFO doesn't understand that, and the way that Indigenous people are criminalized for these traditional practices is something that is very much on BCFNJC's radar and to-do list. But to go back to the family law issue, one of the suggestions that we heard through our fall engagements, and our team did over 80 in-person engagements on different parts of our justice strategy just in the fall alone. So we've been quite busy and all over the province. But we heard on multiple occasions about a desire for the creation of Indigenous family courts. So that's something that we're not doing immediately, but have on our ever-growing to-do list. At the risk of sounding like a broken record, and I don't know if that's an expression that people after millennials use, but I think the addition of family law services to our IJCs will be a hugely welcome change, but it's only a part of the solution. And we're working on transitioning legal aid. We're working closely with Wendy and Michael and others to plan that in a good way. I think one of the things we need to be really careful of, because one of the oldest tricks in the colonial book is to put a limited amount of resources in the circle and have people fight over them. So we really don't want the legal aid transition to look like that. And we're working in a good way to avoid that happening. But legal aid and our IJCs are two parts of our 25-part justice strategy. And for those who haven't read it before, I do encourage you to go visit the justice strategy. It's designed along two tracks. And the first track, what we're talking about mostly today, I call it Band-Aids on a broken system. How do we make the existing colonial system less racist and less painful for the people who are caught up in it? And lawyers have a huge role to play in this, to be sure, but just take a minute and let's do something that's uncharacteristic of our profession. Let's exercise deep humility. Lawyers often come into the situation when it's too late. So many people, their legal matter that is wrapped up in the colonial system, like when they're done with the colonial system, even if they've gotten the best legal aid supports and all of their matters have been covered, and the application process was smooth and they got a great outcome in the justice system, like how many people go home better off for having dealt with the colonial legal system? Don't get me wrong, I'm not saying that track one is not important. It's really important. We need an urgent and radical reform of policing. of prosecution policies, and prosecutors need to do better for First Nations people. So do judges, but this isn't the panacea. The Justice Council, supported by the province of British Columbia and the federal government as well, asserts that the real change where we're going to see those numbers start to climb down isn't through more Gladue reports. That's a Band-Aid. That's our track 1. And where we really want to see change is in track 2, and that's self-determination over justice. That's Indigenous legal orders, healthy communities, healthy families, prevention and healing. And it's not the Justice Council's job to do this for First Nations in British Columbia, but it's our job to walk alongside them to ensure that this work is properly resourced, and to make sure that communities can access these opportunities. We know that nations are starting to reclaim responsibility for the well-being and safety of their children. Let's face it, the colonial system hasn't done well for First Nations children or other children that are in their care. But I think that once there's more movement there, we'll see more self-determination over youth justice and then all of justice. This is a bit further down the path, but just in terms of timelines, I want to speak from my own personal experience. I've had the success, the amazing feeling that comes with advocating for change in the colonial system. I wrote a paper and I suggested reform to one section of the criminal code, and my suggestion was copied and pasted into the criminal code and made law. And that felt really good. And then I realized that it's not going to make a lick of difference for people who are in the existing system. I don't want to spend my career toiling at the edges of a system that was built to take Indigenous people's power away. The status quo is killing Indigenous people. And I think, the real reform and change we're going to see when we move into that track 2 of the system. Miigwech.
Thank you so much, Manda. You mentioned the question in the chat, so I want to turn to that just for folks who might not have seen it, but we did have a question which I'll put to Michael to confirm whether or not harvesting offenses are covered by legal aid, or I think it's offenses under the Fisheries Act through the Department of Fisheries and Oceans Canada.
No, oops. Am I muted? I'm not muted. No, we're good. We looked at this, and it was raised soon after I started at Legal ABC, and we do provide services in the event that the allegations may involve jail time. So, in other words, if it's you don't get jail time from the harvesting offenses, but you can if it tracks over into a violation, as in criminal contempt or a violation of an existing municipal order. And we looked at whether or not we could afford to do that. And as of the last budget, we weren't able to do it. Besides the instances that were covered by that would be treated as akin to criminal, and whether or not we can do it in the next year is something that we're trying to look at in our budget. We have a sense of how many matters there are. We have a sense of what the budget could be, but we haven't been able to figure out an accurate forecast that would allow us to say to the Treasury Board and to the government, we think covering this would cost X. And as a result, we didn't do it last year. But one can be hopeful for next year. And certainly if it's something that BC First Nations Justice Council isn't going to deal with in the near future, then then that's our job to do that for sure, as we do over the long-term transition to seeing our Indigenous clients in all likelihood move over to the First Nations Justice Council. There will still always be a role for Legal Aid BC, and we're all set up, and we've been set up for decades. BC First Nations Justice Council is getting set up at record speed, but we're just in a better position to be able to do it right now. And I would love to do it. I personally would love to do it. this was my background before I got into politics, was harvesting rights. And I worked with firms that represented the unceded territory that I'm on right now, the Musqueams, but we weren't able to budget for it in the last year.
Thank you, Michael. We just have a couple more questions just on this theme of interrelated issues, and I'm going to turn next to Wendy to talk about how the government's supporting the provision of services for clients who have interrelated issues, including and perhaps especially poverty law.
Yeah, thanks for the question, Lee. So I spoke a little bit earlier, kind of at a high level, about the legal clinic network that we fund through the Law Foundation. So currently, there's a series of 8 clinics, both in specialty areas of law like housing, disability, immigration, refugee, and child and youth services. And then there are 4 additional community legal clinics, previously referred to as poverty law clinics, in Kamloops and Kelowna and Surrey and Prince George. And so we work with the Law Foundation to essentially put a lawyer and some other staff in an existing advocacy organization to try and create that rounded continuum of services in that community. And so there is typically an advocate in those clinics, as well as lawyers, and to try and assist more people both with legal information and summary advice, although they are able to take on some full representation clients, just depending on demand. And as we know, demand can often exceed capacity, but that is a place that that's a network that we're working to better evaluate so that we can determine what we learned and how we may be able to advocate for additional resources for that particular network of clinics. The other, Aleem referred to it earlier. Another thing that just in my particular shop, what we're working on is the rollout of the mental health rights advice service. And so statutory changes were made in 2022 to create, although they're not yet enforced because the program isn't up and running throughout the province yet, to provide rights information to people once they've been admitted to hospital. Initially, the service will be available for people on request. Patients will be asked if they want to speak to a rights advisor, and if they say yes, those meetings will be set up. But the intention is for that service to be to transition to, once it's up and running, a service where rights advice meetings will be set up initially for everyone, and a patient can always refuse the meeting if they're not interested, but it just kind of obviates the need for the patient to identify that they want to speak with someone. I mean, those are 2 areas that are not, I think, typically seen as legal aid, as in Legal Aid BC. But Michael spoke earlier as well about the navigator role, which we're pretty excited about, that Legal Aid BC is piloting, just to try and make sure that services are accessible, right, and meeting people where they are, and what their ability is to understand the system and navigate the system. And to try and show up for people and assist them, to navigate the system that we currently have.
Thank you, Wendy. And Michael, back to you. How can Legal Aid assist with ensuring that lawyers and Legal Aid BC staff have the training that they need to protect themselves as well as their clients from being further traumatized when they enter into the legal process?
Yeah, sorry, you suddenly disappeared off my screen. So hopefully you can see me and hear me when I say that Legal Aid BC does provide for this training for our staff internally. It doesn't mean that we're done, but we do provide that training. We are also working with the Association of Legal Aid Lawyers and the Law Society to try and really better equip our lawyers to be providing services to our client along these lines in 2 ways. One, we want them to get the training. Secondly, but we currently don't have the budget to do that, but that's currently the case. There are other potential providers. It could be a requirement by the Law Society of British Columbia. It could be a requirement that we ask of all legal aid BC lawyers if they want to be legal aid lawyers. Also, besides the training, we, again, with a really massive change to our data collection efforts and budget, we are trying to find the lawyers who are good at this, and based in part on the client feedback, of course, but also referrals that we get through our intake system. So now, when I go out across the province, as we've done through, we call it Legal Aid Connect, where we meet with different regions in the province and we get feedback, we do hear stories from, secondhand, thirdhand stories from community service providers who are in the business of helping people, like we said before, Amanda, prepping people for dealing with legal aid, which is something that we would love to end very soon so that it was more user-friendly for our clients. But in any event, we get the feedback, hey, you've got some lawyers who are definitely not trauma-informed and are definitely not conducting themselves in a fashion that is equitable and inclusive. And there are horror stories of discrimination by counsel themselves. Now, these are secondhand. So we are, trying to do everything we can to both equip lawyers to do that and engage in the quality control that you would expect of, I guess the best way to describe us as the service provider who's contracting with these lawyers in order to ensure that that happens. All of our navigators also have those tools and that expertise. They are non-lawyers, but this is what they're good at. One of our navigators was on East Hastings 4 years ago, not voluntarily. He has the experience of working through the social safety net, and he's got the experience of working with people in trauma. He's got lived experience. We have other people with lived experience in different ways. One of them being one of our navigators was a refugee and sought refugee status using Legal Aid BC, and now he's using that lived experience to help others. So this is a primary qualification for folks who we're now hiring. We are looking for people with lived experience, and we have, as much as we can have a preference for that, we have a preference for that. As I said, because of the nature of the work we do and the clientele that we have, it's a critically important skill for all legal aid lawyers and for legal aid staff to have that. And I'll leave it at that.
Thanks very much, Michael. And you've started us off into the next and final major theme of our discussion today, which is the role of innovation in enhancing legal aid service delivery. And a couple of examples of that, we've just mentioned the navigators. There's also potentially restructuring legal aid funding to allow for a graduated scale of financial eligibility to bridge the gap for those who make a modest income but can't afford a lawyer. As well as mixed models of legal aid services for family law and poverty law that could include a range of services through tariff contracts, legal aid clinics, and in-house counsel. And that could increase the choice of service delivery to clients depending on their needs. Michael, I'm going to turn back to you, and you've given us some more information about the navigators, which is really helpful. But if there's some further information about the navigators or other areas in which you think that people who aren't lawyers, especially, can participate in addressing the gap between existing coverage and the existing need?
Well, for non-lawyers, my short answer is that the thing that people outside the system, lawyers, can do is, if you're a lawyer, to sue us, bring public interest litigation to get changes that are not happening through democracy. That's realistically the way in which some of the changes will take place. And so even though we can't sue ourselves, We have to conduct ourselves in a fashion that's consistent with our fiduciary duty. Nevertheless, there's not enough public interest litigation in this country, in my view. Used to head up Canadian Civil Liberties Association, and our experience was, in some areas, democracy is not a friend to those who are in pain and are in need of these services, and the only solution ends up being public interest litigation. So that would be one thing. Access Pro Bono is a place where lawyers and non-lawyers can go and volunteer and assist in a variety of different ways. For lawyers, of course, one can do, and we encourage people to do pro bono and low bono work. Granted, I'm not suggesting that that's a solution. But it's something that people can do. In terms of the different models and the innovative models, and the discussion about trying to assist people who are perhaps above the poverty line, who could afford some of the fees. Legal Aid Ontario went at this in a serious way for about 4 or 5 years, and the results were not encouraging. The effort needed in order to determine the exact financial ability, attach to the assets, collect the money. It was costing more to collect than it was in the services that they were able to provide. So now that doesn't mean that we give up on the idea and that there isn't a future there. It's just that no legal aid system has become great at that. And the last thing I'll say about that is that the hard part about innovation, I think, within the legal aid system, and this is true, I think, through the charitable and not-for-profit sector, and through government sector as well. Wendy Jackson is somebody in the Ministry of the Attorney General who works on innovation. She works on policy. She tries to come up with different ways and innovative ways of doing things. There aren't 100 Wendys over there in the Ministry of the Attorney General. They've got some folks, but not many. And similarly at Legal Aid BC and in certainly CLASS as well, these different funding models, different ways of doing different things with revenue, you can only do that if you're making investments in the internal infrastructure, if you like, of the organizations themselves. But treasury boards, governments, funders, they don't like that. They want their funds going directly to client services. And I understand that. I want that too. But it is going to involve some leadership and investment so that organizations like Legal ABC say, we're going to develop our capacity for R&D in order to try these different things and do these different things better. But that's a shift and an effort that, in turn is going to require governments and Law Foundation as two examples to permit it to happen. Law Foundation is very encouraging on that front. And I should have said that our navigators at present are currently fully funded by the Law Foundation of BC. So they really started that. If navigators are the beginning of something great in access to justice in BC, it's thanks to the Law Foundation. So I think that's the best way I can answer that question. We're going to have to make the investments in order to come up with a different innovation. That said, we're doing that right now in terms of the way in which we're collecting data so that we're trying to moneyball legal aid. And if you don't get the reference, I'll explain it in a future question.
Thanks very much, Michael, and everyone heard it here first. Sue us, innovation through litigation. And sometimes that might be one way to do it. And speaking of that, we're going to turn over to Aleem actually with CLASS, and he does some of this work. Aleem, how do you think more innovative legal aid delivery can help support clients such as those that CLASS takes on, who are facing issues with housing rights or workers' rights, human rights, and other mental health issues and rights?
Well, I think one of the biggest practical barriers is the application for critical legal services, is lack of information, geographic inequities, and language barriers. For some mental health detainees, for example, They won't understand which legal regime is holding them, how to get basic legal services to address their issues. In human rights, as another example, despite those whose human rights are accepted by the human rights complaints are accepted by the tribunal, and them being informed at the outset through written communication about the availability of our clinic, many only come to us late in the day at an urgent juncture in their legal proceeding when they've been personally referred by the tribunal. When we ask why they didn't apply for our services earlier, they often say they weren't aware of them. All of this is to say what is desperately needed. This is, I guess, mirroring some of the ideas about the navigator, in my view, and view of many others, is a single accessible staff service that will take the time to understand a client's issues and provide very detailed and guided referrals to the appropriate legal services that exist and are available. This single referral service should keep stats on demographics and the ability of the system overall to address people's critical legal needs. It should have a prominent website that is well known and linked through all the other legal service providers. And it can't just rely on the technology, which, as we've heard, is not accessible to all. It should have outreach capabilities, on-the-ground connections to more remote areas, as well as itself be trained to be able to serve people from various backgrounds, specifically to be culturally aware regarding Indigenous clientele, to deal with people who may have suffered assorted traumas, speak different languages, have a range of abilities. So this isn't to dismiss the gaps in services that exist that can't be addressed purely through innovation. I mentioned gaps in mental health, sexual harassment, limits of some of our services we provide that often don't include full legal representation. And we've heard about the significant gaps in family law legal aid that are well known in that sector. That said, if we could all be working together, all the various stakeholders we see involved in Access to Justice Week's presentations, to make a comprehensive navigation and referral hub beyond the the corners of legal aid, if we could make that a reality, I think that would be a very great innovation for the system overall.
And Amanda, we're going to turn back to you now. Strategies 3 and 5 of the BC First Nations Justice Strategy directs the BC FNJC and Province of BC to work together to transition legal aid services for Indigenous people from Legal Aid BC to the BC First Nations Justice Council. And you've talked about this a little bit so far, but we want to delve into that a little bit more if you have more on it, in terms of what opportunities exist to increase access to justice for Indigenous people through this transition, and what role organizations like the CBABC or individual professionals who are attending today can play in the development and implementation of the transition.
Lee, I always have more to say. Thank you.
And I'm glad for it.
Happy to keep chatting. First of all, I mean, if we needed proof of the fact that it's time to move away from the colonial legal system, the very phrase innovation through litigation and the wasted resources that entails is makes it pretty obvious, in my humble opinion. I also just wanted to echo thanks and gratitude to the Law Foundation. The reason that we have been able to grow in this way that is just overwhelming is large part in thanks to the Law Foundation, as well as our funding from BC and the federal government as well. We're so grateful not only for the resources that the Law Foundation has made available to the Justice Council, but there's a new fund of money that's available for community-based justice programs that's available. So if folks who are here haven't heard that call from the Law Foundation, I would strongly recommend that you look at that. There is a question from Anne in the chat about child protection clients whose legal aid lawyers are not covered to address denial of EFT, which I'm told by my colleagues who are more knowledgeable about this, that is extended family care. So what I have also been told by my colleagues who are in the management of the IJCs, which I'll talk about soon, is that we can do that work. we hopefully will have enough lawyers to do that work. I don't know how many cases this is that we're talking, but certainly that's something to contact our Indigenous Justice Centers about tomorrow morning. So hopefully, if nothing else good comes out of today, hopefully we can get some help for folks who need help on EFCs. The next thing I wanted to talk about is our Indigenous Justice Centers. So we have 5 new regional Indigenous Justice Centers, thanks to the province of British Columbia and the funding that's been made available through the Safer Communities Action Plan. Those regional Indigenous Justice Centers are in Vancouver, Surrey, Nanaimo, Kelowna, and Victoria. They join 4 brick and mortar Indigenous Justice Centers that have been in operation. Prince George, Prince Rupert, and Merritt have been in operation for a couple of years. That was early work that the Justice Council did, starting in 2021. And our center in Chilliwack opened in June of last year. We also have a virtual Indigenous Justice Center that serves Indigenous folks in the province in places where we don't have a justice center. And right now that's looked like lawyers traveling all over the place, which is also not the best use of resources. But I think as our network expands, we'll be able to be a lot more efficient and serve a lot more people. Our Indigenous Justice Centers house staff lawyers, counselors, in-house elders, aunties, navigators, and more to provide holistic services to Indigenous people who find themselves involved in, as I said earlier, the criminal justice, or criminal or child welfare matter. The hope is that our legal aid service model, which will include staff lawyers and wraparound supports, can support a client's need in a holistic and culturally appropriate manner. We want lawyers to be more accessible, to have more time with their clients. We want to ensure that Indigenous people and families will be able to receive mental health and wellness supports to help address some of the root causes and reasons that they're there at the justice system. And I think, in terms of innovation, the bottom line for me, and when I think about the experience of an Indigenous person who's walking into one of our Indigenous Justice Centers, whereas, and not to be overly critical to many lawyers who are providing excellent services to people through a really challenging system that is legal aid. Lawyers have a vested interest in having repeat customers. And that's the difference that we want to have with our Indigenous Justice Centers. We want a person to come in to our center, they're charged with a criminal matter, they're at risk of losing their children, and we want to look at everything in that person's life that led them into that justice center. We want to solve their legal problem with world-class legal services, and we want to solve all the rest of their problems insofar as is possible, so that the next time we see that person, they're working for us, and we're not serving them again with a legal matter. And that's not typical of the way that lawyers typically do their jobs. We're in the process of developing an Indigenous-led model of legal aid services, as I mentioned, guided by feedback from our engagement sessions and research that is ongoing. In terms of timeline for the transition from Michael's shop to our shop for Indigenous people, the implementation of the new model is going to be done incrementally over several years, starting in 2025. We are piloting other projects because, of course, now we have these big, beautiful Indigenous Justice Centers and super awesome lawyers who are excited to start serving people. So there will be different pilot projects that are happening so that, we're not saying to every person who walks through our doors, oh, actually, you're eligible for legal aid, then you got to go over to legal aid shop. So, it's part of the really good collaboration that we've had to this point with legal aid is, being able to pilot these projects. And we really want the legal profession to work alongside us and commit to the task of decreasing the number of Indigenous people that are incarcerated, as well as the number of Indigenous children who are in care. I feel like I've probably already done my share of soapboxing, but just in terms of closing words, I wanted to quote one of my colleagues, Kristen Barnes. She's a GitSan lawyer from Git and Max and an incredible member of our policy team. And in relation to something else, she wrote something, and her words are so meaningful to me, and I wanted to share them with you. And she wrote, people, although well-meaning, often look to the development of new laws, policies, programs, and services to solve issues that started as a result of laws, policies, programs, and services imposed upon First Nations by foreign governments. The solution to these issues cannot be found in the cause of these issues. Systemic racism, poverty, homelessness, dislocation from community, loss of language and culture, and the disruption of traditional family roles and customs can all be traced back to the assimilationist laws, policies, programs, and services imposed upon First Nations and the populations following the introduction of the Indian Act. These issues did not exist pre-contact, and they were caused by the complete disruption of First Nations systems. Thus, the answers to these issues can only be found in the complete disruption of imposed systems and a return to legal agency of the communities themselves. And, you know, I'm grateful that I get to work with incredible people like Kirsten. Our team, and I've been with the Justice Council for just less than 2 years, and there was fewer than 30 staff when I joined, and we're now at over 130, getting close to. It's a special kind of person, and especially a special kind of lawyer who wants to come and work for the council. If we're really good at our jobs, we won't be practicing law in the colonial system for that much longer. And that's a little bit scary. It's a lot scary. You know, it's a lot scary for people who have invested, you know, 10 years of their life going to undergrad and going to law school and articling, and then, you know, building a career in a system. Like, it's really scary to talk about moving away from that system, or, you know, some might even say flippantly blowing up that system. But, you know, I think if we actually want to see change, and, you know, we have to think about radical change, and just doing more than more resources into a system that doesn't work, not only for Indigenous people, but frankly doesn't work for a lot of non-Indigenous people as well. So thank you.
Thank you again, Amanda, for some really powerful comments and contributions to this discussion. I did want to highlight for people some comments from Wayne Robertson in the chat about the important work of the Association of Legal Aid Lawyers in BC and what they're doing and their role in some of this as well, if you haven't seen it. And also to encourage people to add questions to the Q&A if you have any, because we will have a couple minutes after my last formal question to address anything else that has come up. And my last question, or pre-prepared question with forewarning, goes to Wendy, which might interestingly take up some of what the quote that Amanda just provided, and that is, what is the role of government in supporting innovation in this sector?
Yeah, so thanks for the question. It's always hard to follow Amanda, so thanks for that. But I mean, I think there's a couple of different roles that we play. Addressing specifically what Amanda said, you know, to provide some investment and then to kind of get out of the way, you know, and to obviously to work with and support the people who are properly doing the work in the space. And so that is one role for government, I think, in innovation. It's challenging sometimes because government shows up as a party, as well as the funder of the system, as well as the funder of other services. And so that's why the ministry has lots of different arms to do the different, to play the different roles. In particular, from a policy perspective, you know, we are a connector. We interact with the judiciary, the service providers, and try and facilitate that kind of collaboration, systemic collaboration, which, you know, requires investment, both and resources. And it's not just funding, it's people. It is true there is only one me, and so, you know, there's a limited amount of, we can't be everywhere all at once. Another movie reference for the folks at home, but the you know, to fostering continuous improvement, right? Someone's already talked about continuous improvement today. Things like the Family Law Act modernization piece, right? Like making sure that the laws that exist and the frameworks that exist are continuing to serve the people of British Columbia. Things like, you know, like the complete repeal and replacement of the Family Relations Act at the time, right? Creating the definition of family violence, which has now been echoed by the feds a decade later, right? So these are the kinds of ways in which we show up in the sector and in the system. and try really hard to do what we can for the citizens of British Columbia. When I think about policy, I think about, you know, user-centered service design, the people who are using the system. Sometimes it's lawyers, but by and large, it's citizens, right? And lawyers are supporting citizens in their engagement with the system. And so when we are piloting new ways of doing things, you know, perhaps not as robustly as Amanda is talking about with the council, but it can sometimes be scary for people in the system who, because they know how it works. And but the only way we're going to learn about how we can do things better, or, you know, more, you know, efficiently and effectively, but most importantly, to get better outcomes for people, longer lasting outcomes for people, so they don't become our customers again, as Amanda quite clearly points out, right? You know, hopefully, if you can do a really good job helping someone with their family law matter, they, you know, you don't see them again because they have existing orders and they have a system that in place that works. And so, from government's perspective, you know, like we create the framework and we facilitate those conversations to make sure that we're looking and doing that continuous improvement work.
Thank you, Wendy. And I agree, it is hard to go after Amanda. And I have one question for Michael in our Q&A. If anyone else has any question, now's the time to get it in before we wrap up. But to Michael, the question is, did you say that cost containment was the goal of legal aid originally, and then better outcomes were also added as a goal? I would have thought that better outcomes would have naturally been the goal of legal aid. What prompted the addition of better outcomes as a goal?
Like just about everything I do, it was an overstatement, but I think it's true. I think that if you look at the first few decades of legal aid across, in Canada, the United States, and United Kingdom, it was a movement, and it was a movement about assisting the underclass, about assisting the impoverished and people who normally politicians don't want to be seen to be assisting, which is people charged with crimes. The ignorance as to the racist nature of the justice system was unknown, but the system grew and grew and grew and grew, and you saw the legal aid systems across the country grow until the next generation of legal aid, which was about forcing legal aid corporations around the world to become a business, and a very efficient business, because of the scrutiny that was brought to bear from Treasury Board and Ministry of Finance. So in British Columbia, after 2003, the idea is legal aid was shrunk. Legal aid BC was shrunk down to the point where it was only assisting where it was required to assist under the Constitution. Without legal aid, there'd be a Robotham claim, basically. But anything beyond that, no. So understandably, legal aid plans across Canada anyways had to become very efficient, cost-containing businesses. They wanted better outcomes for the clients, but in order to do that, you've got to be strategic, and you need to start collecting data. And I think that some legal aid administrators in Canada were agnostic as to whether or not the corporation itself, legal aid, could itself drive outcomes. So, for example, you can make an argument that the amount that you get for a guilty plea in a sentencing hearing creates an incentive for that if you compare it to the amount that might be collected if it goes to trial. Do we financially incentivize divergence, for example, diversion? Do we financially incentivize charges getting dropped? And other examples where we're creating greater liberty in exchange for an investment in it. One of the things we wanted to look at, and this is an idea we talked about with Wayne Robertson at the Association of Legal Aid Lawyers, unique situation we have in BC with the Association of Legal Aid Lawyers, where we basically can bargain every few years, get some certainty, and it's as a result of that a huge increase happened a few years before I started Legal Aid BC. I had nothing to do with it. And that is, what if we made investments, greater investments around bail, so that we got folks out? If we made those investments and it worked in theory, we got people out and not pleading in order to get out of jail. I have lived experience as a legal aid lawyer. I have lived experience as somebody who's been charged. And I can tell you, for me anyways, I wanted out of that cell, and I wanted out bad. And it would not have at all have been difficult for me to imagine that pleading guilty would be something that was logical if you want to get free. And if you spend night after night after night, you and your lawyer says, well, you can plead guilty and you've done time served, many people will do that. Well, is Legal Aid BC incentivizing that, or are we incentivizing better outcomes for our clients? So what we're trying to do is be more strategic. We still have to do the cost containment work, but we do that. We know how to do that. What we're trying to do is not let the urgent get in the way of the important. And the urgent is, all of the, as I mentioned, thousands of matters that come into the system every month. The important work that we can do is the anti-racism work, the reconciliation work that's going to get better outcomes for our clients. That's the new strategy of Legal Aid BC. Maybe we're just saying it differently than it was done in the past, but that's the strategy. It's to get better outcomes for the clients, and we're coming up with particular strategies. The hardest one is family, because what's a win in family when you have two people right in a civil matter? But that's an example where if the person leaves the experience feeling greater autonomy and safety, well, I think that's a win. I think that's a success. We want to do more of that. On the criminal side, there is more certainty. On the child welfare side, there's complete certainty. We can just win those matters and try and keep the family together. And lastly, with refugee applications, same thing. We just want to win more. That means also working with the lawyers who tend to be winning more. But then you've got to put into account the complexity of the cases. The prosecution is doing this. The Crown attorneys do this. I want defense to do it. And so that's exactly what we're trying to do.
Thank you very much, Michael. And with that, we're at the end of our time for the panel today. And I want to give everyone a huge thank you for joining us and spending some time with us today for the CBABC and CLEBC event. And my sincere thanks to the insight and engagement of our panelists, Amanda, Aleem, Michael, and Wendy, for sharing your knowledge and your views with us today. I also want to do a shout out for those behind the scenes, both at CBABC and CLEBC, who do a lot of hard work but remain unseen. They do the magic behind the scenes to make sure this all comes together nicely. Thank you kindly once again, and please enjoy the rest of your evening. Good night.